It's the Law.
Welcome to It's the Law, a program produced and presented by the Guyana Association of Women Lawyers. On this program, a member of the association gives us an in-depth look at Guyana's laws. Today's topic is protecting yourself from domestic violence.
Hello everyone, I am Alison Welch Critchlow. I am an attorney at law and a member of the Guyana Association of Women Lawyers. So I'm here today to let you know a little bit about how you can protect yourself from domestic violence. And one key piece of legislation that allows for that is the Domestic Violence Act, Chapter 1109, which can be found, of course, in the laws of Guyana. So let's get straight into our topic for today. What is domestic violence, some persons may ask? When you think about your health, safety, and well-being, it can be protected by law and protected by that same bit of legislation that I spoke about earlier, the Domestic Violence Act. And this act allows you to take out certain types of orders against a person you associate with who may be causing harm to you or who may be threatening to cause harm to you. Some of these acts of domestic violence may include, for example, hitting, some persons may say physical abuse, raping you as well, which comes under our Sexual Offences Act, verbal abuse as well, persistently texting and calling you against your wishes, limiting your access to and use of your belongings or hiding them, intimidating you as well by repeatedly doing and saying things to put undue pressure on you. Additionally, limiting your access to food as well can be seen as domestic violence. Limiting your access to your children, preventing you from spending time with your family or friends also. And I might add, drugging you or forcing you to take a drug is also considered domestic violence. And this is just to name a few. So when we think about what domestic violence is, we can get straight into some of the protection persons can seek under the Domestic Violence Act if they are exposed to domestic violence. So who can apply for a protection order? Let's start there. Some persons may know that a police officer or a social worker can apply for an order to protect you or any child who resides in a household. It does not necessarily have to be the person who is being abused. And of course, definitely the person who is being abused can definitely apply to the court for a protection order, for example. And when I say anyone, anyone female, male, young, old, anyone can apply to protect themselves. A person, just to note, younger than 16 may apply to the court to protect themselves if they feel that they have sufficient understanding to do so. Alright, so let's move on to who you can get a protection order against or any order that comes under the Domestic Violence Act. A person, an individual, they can get a protection order stopping someone you associate with from inflicting any harm that was mentioned before or threatening to harm. And when we say associate, the act actually defines what that means. So a person you associate with includes someone you were married to or someone you are married to currently, someone you would have had a sexual relationship with, or someone you are currently having a sexual relationship with. Person living in the same household with you, or someone you used to live with. General, someone you are related to. Additionally, someone that you may currently be engaged to be married, or someone you were engaged to be married. Further, as well as a parent, the adopted parent or a grandparent of the child or adopted child. So you can see the word associate. It's very expansive and it details who someone who is going through domestic violence can get an order against when it comes to the Domestic Violence Act. So let's talk about some of these orders that you can get under the Domestic Violence Act. What can the court order? There are three main orders, I would say, that the court can order or someone can get within the Domestic Violence Act. Those three main orders are a protection order, an occupation order, or a tenancy order. There are other orders. For example, the court may also order that the person who has been abused have custody and use of any furniture, household appliances, and effects that you need. Just to add to that, there are interim orders for urgent situations as well. Let's say, for example, the situation is a very urgent one and you need protection or you need a protection order right away. The court can't make an interim protection order, an interim occupancy order, even before the individual who that order is to be made against is served with a document for them to appear before the court. This can happen when it's necessary to ensure you or your child's safety. But let's get back to the three main types of orders that I've mentioned. So we have the protection order, the occupation order, and the tenancy order, just to give you a little bit more insight on those. So the court may make a protection order that may, 1, stop the abuser from being on premises where you live, work, or go to school, or frequent. 2, stop the abuser from being in your neighborhood. 3, stop the abuser from engaging in harmful conduct. 4, stop the abuser respondent from harassing you or psychologically abusing you. 5, stop the abuser and anyone on their behalf from contacting, calling, or messaging you. 6, directing the abuser to contribute to maintain you or the person you are protecting. 7, direct who has custody of any child or children that may be involved. 8, stop the abuser from taking personal property you need to use. And this is inclusive of identification documents, birth certificates, etc. 9, direct the abuser to return your personal property to you. Examples that were listed not too long ago. 10, direct the abuser to get counseling or therapy. So those are some of the things that can be listed within an application that will be made before the court where the survivor is seeking a protection order. So the protection order is not just limited to the abuser stop physically or verbally abusing an individual, but there's so much more. And I would like to add to this, I know a lot of persons are familiar with the term restraining order, as we would hear it often. Just to let you know, a restraining order actually forms part and parcel of a protection order. So you can get that within an application for a protection order. One of the other major court orders that can be sought under the Domestic Violence Act is the occupation order, as was mentioned. So the court may make an occupation order granting you the right to live in the household residence and stopping the abuser from living there. Basically, the court can ask the abuser to leave the household. If the court finds that it is necessary for you and your children, if children are involved, for their protection. And the third main order is the tenancy order. If the household residence is a rented and the abuser is the tenant, the court may order that you are to be the tenant of the dwelling house instead of the abuser. And this simplifies to say that if the abuser is the named party on the landlord and tenant agreement, the court can order otherwise. In this regard, the court will give notice to the landlord or owner before making this specific order. So as you have it there, those are some of the court orders that can be made under the Domestic Violence Act. Okay, so just to give you a little bit about procedure when it comes to that. How do we apply for these said orders? This is done by filling out an application at the magistrate's court in your area or within your jurisdiction. When you go to the said magistrate's court in your area or jurisdiction, most of the magistrate's courts, there is an assigned clerk that deals with applications that fall within the Domestic Violence Act or matters of domestic violence. So you would go to that specific clerk and that clerk will be able to assist you in filling out the particular application, and the application will include basics such as your name, your address, the respondent's name, the respondent's address, and the respondent is the abuser, just to be a little clearer. It will also include details of how you and the respondent are associated, because remember earlier I mentioned that you can get an order against the person you associate with, and I had given some examples. So you have to show on this application what the association is, as well as the details of the conduct you complain of. So you have to make it clear in that application what has transpired or what abuse has occurred in order for the court to make the order or whatever order necessary. So the said application is then filed, and a hearing date is usually set within 7 days of filing the said application. If you would recall earlier, I mentioned when there are urgent applications, usually an interim order will be made. And then once that interim order is made, you will have some time thereafter to serve that on the respondent or abuser, and they will be given a court date to come back to make that order final if that is the case. So yes, a hearing date is given. The application naturally is to be served on the respondent or abuser. And once that is done, there's a court hearing based on the date given. The hearing is conducted and the order is made, or whatever decision of the court is taken. Just to be clear about some procedure. Okay, so now a little bit about after you get an order. Just some important things to note. The respondent or the abuser must obey the order as soon as they know of it. They will know of it at the court if they are present. And then in some instances, the respondent may not show up or the abuser is not present. So they will have to be served with that order at a later date, and then they may become aware of it that way. And what happens if the respondent does not obey the order? I know a lot of persons may be asking about this. Please note and note clearly, it is a crime not to obey an order. And the police have the power to arrest any person who is breaching a protection order, for example, or harming you or anyone in your household, even before you get that protection order. So, it goes both ways. You can make a report to the police even prior to getting a protection order. But once you have that order as well and the person breaches that, you are encouraged to make a report again so that the person can be held accountable. When you get a protection order, if the respondent harms you or tries to harm you or breaches the order in any way at all, they may be arrested, prosecuted, fined, and jailed as well. So there are possibilities. So an order must be obeyed. A little on duration of the orders. A protection order, occupation order, tenancy order, what have you. They last for as long as the court directs. So naturally, the court will indicate whether it's for 1 year, 2 years, 3 years, what have you. And 2, from that, the person who applied for the order, them or the respondent can actually apply to vary or revoke the order. And this can happen if circumstances change. Let's say both parties, they wish to, for example, there is a spouse, man and woman, and they wish to work out things, they wish to consider counseling, they want to work on their relationship. The party who took out the order can go to the court to have that order revoked. So there are options in that regard. And if someone applies to revoke or vary an order, a copy of that application must be served. And in deciding whether or not to revoke or vary the order, the magistrate will look at how best to protect you, the person applying for the said order, or the child's health, safety, and well-being. So those are some of the key things that you need to take away from the Domestic Violence Act and when you're thinking about protection from domestic violence. And just to wrap it all up, For persons who may be looking for assistance when it comes to domestic violence or any form of violence, and you wish to report said violence or you wish to seek assistance, you can call the Domestic Violence Hotline, which is part and parcel of the Ministry of Human Services and Social Security. And that hotline is a 24 hours hotline, and that number is 914. Thank you.
You have been listening to It's the Law, a program produced and presented by the Guyana Association of Women's Lawyers. The contents of this program are not to be taken instead of legal advice.